10 commercial real estate terms you should know before signing a lease. I'm Remy Isdaner with Mirlo Real Estate Partners, and in this video, I'll be sharing 10 commercial real estate terms you should be familiar with before signing your lease. If you are new to this channel, please be sure to like, share, and hit that subscribe button to get notifications on all of our videos. The first term we'll cover is abatement, which can also be referred to as rent abatement. These terms both refer to free rent. Abatement, or free rent, is a lease concession that is negotiated during the LOI process. While the free rent period often occurs at the beginning of a lease term, it can be planned at any point. The abatement period may be a part of the term length or added to it. For example, you may have a 5-year or 60-month lease with an abatement period of 3 months. The landlord may wish to sign a 63-month lease term to provide themselves with the full 5 years of rent, rather than the 4 years and 9 months. Depending on how strong the market is and the specifics of your deal, free rent is a common lease concession provided by landlords to ensure tenants are successful while they're getting up and running. Our second concept is as-is condition. Most purchase transactions will be delivered in as-is condition, meaning the seller will not make any changes to the property prior to closing. Note that some leases can be delivered in as-is condition as well. Reasons for this might be that the space is already in great condition. Perhaps the previous tenant was only there for a year before going out of business. Or the tenant is a chain restaurant with very specific design plans for the space, so they will be doing all of the construction themselves. In either of these cases, the tenant may be able to negotiate other rent concessions in lieu of a tenant improvement allowance, which should be discussed during the LOI process when all deal points are being negotiated. Assignment, or the transfer of a lessee's interest in the premises, is our third topic. This is common for a company whose business is centered around a particular person, such as a doctor, a lawyer, or even a startup's founder. An assignment clause is located in the lease and would be negotiated in the LOI or once the first draft of a lease is provided. An assignment clause can be critical to the tenant because it allows the specific individual to sell or leave the business by transferring the lease to a new person or entity without being attached to the lease. This is different from a sublease because a sublease requires the original tenant to be involved. A tenant who subleases to a subtenant will essentially assume the role of a landlord to their subtenant, while they remain obligated to the property owner by way of their original lease. In other words, they become the middleman between the actual landlord and their subtenant. Base year is our fourth concept. This is the year that is tied to the actual amount of expenses for the property taxes, insurance, and operating expenses, sometimes called CAM, to run the property in a specified year. In a new lease, the base year is most often the year the lease is executed or the year in which the lease commences. Base year is not relevant with the triple net lease, which requires the tenant to pay for all of the operating expenses, also known as the 3 nets, regardless of the increases. However, in a modified gross lease, the tenant will not be charged for the operating expenses for their first year, the base year. Rather, the tenant will be charged for the increases of the operating expenses each year thereafter. For example, if the nets are totaled to $8 per square foot for the base year and $8.25 per square foot the second year, the tenant would be paying 25 cents per square foot for the second year. The lease structure will be determined by the landlord and communicated right at the beginning of the research process, so you should know right away if the base year is going to matter to you. Building standard. Our fifth topic refers to the specific list of construction materials and finishes for the tenant's build-out. The build-out standard is determined by the landlord and provided to the tenant as options to choose from during the space design process. A building standard is set to provide both a uniform and minimum quality standard, while establishing what is or is not considered an upgrade. For instance, if a landlord provides specific work for the tenant's build-out, the landlord will present building standard options that cover things like materials, paint, flooring, and lighting. If the tenant chooses to have upgrades, the tenant will be expected to cover the difference. Our next topic covers dates and is a 2-for-1. A commencement date is the date upon which the landlord and the tenant's rights and obligations under the lease begin. This typically follows a build-out period and commonly occurs when the tenant opens for a business. The commencement date can be synonymous with the lease start date, when the lease is signed, but is not interchangeable as a rule. Rent commencement date is the date upon which the tenant's responsibility to pay the landlord for use of the space begins. A rent commencement date is very often contingent upon the completion of improvements performed by the landlord, or following the period of free rent. Exclusivity, also known as non-compete, is a clause in a lease that gives the tenant the exclusive right to a particular use at the property. A good example would be a retail tenant who sells coffee. They would want an exclusivity clause to be the only tenant in the building who sells coffee and other related products. This clause is most often used by retail tenants and doctors, but it can be used by other types of tenants too. Depending on the importance of exclusivity to your business, this point can be discussed during the LOI or lease review phase. It's also important to know if other tenants within a property of interest have exclusivity. For example, if you sell home goods, there may be a tenant in the same building who sells candles, and they happen to have an exclusivity on candles. If your business happens to have candles too, your use would not be allowed at that building. Holdover. Holdover refers to possession of a premises after the term expires. This is another clause located in the lease and can be negotiated during the time the lease is reviewed. A landlord will often have a holdover clause in the lease that states the tenant will have to face a penalty, such as a much higher rent each month, if they stay past the lease expiration date. While this protects the tenant from immediate eviction, the higher rent incentivizes the tenant to renew their lease as soon as possible. The penalty due on account of holding over can typically be negotiated. Personal guarantees. A personal guarantee is an agreement that refers to an individual's legal promise to carry out the responsibilities of the lease. Given the often large upfront investment the landlord often makes on behalf of the tenant, the personal guarantee provides an extra level of protection to the landlord that they will be repaid throughout the lease. If your landlord requires you to personally guarantee the lease, you will likely need to show your personal financials, similar to what would be required for a home mortgage or new credit card. It's worth noting that the terms of a personal guarantee can be negotiable. For example, your personal guarantee agreement could expire or reduce after a specific period of time during the lease. Our final topic is pro rata. Pro rata is a Latin term meaning in proportion and is used in commercial real estate to describe how something can be proportionately divided. How does this affect you? A tenant's pro rata share equals the amount of space they occupy at a property in comparison to the other tenants and is expressed as a percentage. For example, if a tenant occupies a 3,000 square foot space in a 9,000 square foot building, their pro rata share is 33% of the building, and they would be responsible for 33% of the total building expenses required under their lease. The pro rata share of something is often the easiest and fairest way to split charges among tenants, and it is simple to adjust if the size of a tenant's space fluctuates. Depending on your lease structure and how utilities and expenses are calculated at your property, you will determine if you need to pay attention to your pro rata share of the building. Commercial real estate can be complicated and difficult to navigate. So, if you have any questions or comments about what I've shared today, please feel free to contact me directly by email or phone, or leave a comment below. If you found value or liked the video and would like more information on how to properly navigate the commercial real estate world, check out these other videos. Again, I'm Remy Isdaner with Mirlo Real Estate Partners, and I can't wait to connect with you again.